Things I wanted to go over is just very briefly the differences between a provisional and a non-provisional patent. We covered provisional yesterday, and I think that I made it clear that one of the things I like to do is suggest to my clients that they comply with more than just the minimal requirements of a provisional patent application. I like to have it set up so that it's nearly in the form of a non-provisional patent application. It makes the ultimate filing of a non-provisional application that much easier. And I always think it's better to have all your ducks in a row and really know what you're doing before you go in there. But here are some of the differences between a provisional and a non-provisional patent application. Again, there are really no forms. Yeah.
Sorry, I'm like looking ahead, but so in patents, you like the drafting style, like almost hasn't changed, and it's almost like that line drawing. Is that, it's like hand ink drawn. Is that still necessary, or can you do like industrial draft prints?
You can do either.
Okay.
The idea is to describe your invention so that the examiner can determine that it has novelty, that there's the non-obviousness requirement. All the requirements of a patentable product are what you're trying to describe. So if you can think of a better way of describing it, I imagine, and I don't know this for a fact, but I imagine that video has been used. I can think of instances where you might want to demonstrate a device or its novelty, or its non-obviousness, or its utility by video. So how you describe it in figures and diagrams, I think is open to whatever creativeness that you have. Some patent examiners get nervous when you get off the track, but I would not let that stop me. And depending upon the complexity of the invention, you may want to use unique ways of describing it. So anyhow, the difference is higher filing fee, of course. It does depend on how many claims you have, but generally provisional is about $125 and a non-provisional is $550. But again, that depends on the number of claims. It's more complex and sophisticated drafting. That's only true if I don't represent you. We're really talking about the minimum requirements that are set out in the patent statute, and which the USPTO requires. But as we all know now, we want to be more. We want to provide more than what the minimum requirement is. A specific application format is required. Well, that's true, but as we went over yesterday, we cover most of those voluntarily, if you will, in our provisional patent application. The one thing that you have to have that is different is claims. Now, with the provisional patent application that we sent around yesterday, there was a whole section about objectives. And we all know how to frame the phrase for a claim section. It begins with "I claim that" or "it is claimed that." So that, for instance, the objective section from the provisional patent application that we saw yesterday can be turned into a claim section by just putting the words "I claim that" or "it is claimed that" before them. A declaration is required. Again, it's a formality that I think that maybe you can use in a provisional patent application as well. There's nothing that says you can't use it. Obviously, it is required, however, for a non-provisional application. The information disclosure statement, and in this case, they're all examined by the USPTO. Many provisional patent applications get approved without any examination by the USPTO. If not precluded by prior art, that which has been done before, and if adequately explaining the invention, the application will mature into a patent that confers the right to prevent others from making, selling, and using your invention. Of course, Easier said than done. Yesterday we talked about the average time for taking a patent from application to final approval being about 3 years. In my experience, that's a little optimistic, especially when it comes to more complex methods, inventions, processes, devices. Sometimes that can be 4, 6, 8, and I've even seen it 10, 12 years. As you know, there's a back and forth between the examiner, once the examination has been completed, and the inventor or their representatives, where they try to explicate the descriptions to the extent that they may be inadequate, to the extent that maybe the examiner has thought of some other uses, some other potential claims. One of the things I think that you'll find, and I know that we all have sort of a jaundiced view of government, but pretty much uniformly, my experience with patent examiners and other professionals at the United States Patent and Trademark Office has been very good. There's an awful lot of talent there to be taken advantage of. Remember, it may be your first or second patent application, but when you pick up the phone and dial their 800 number and speak to an examiner who are available to speak to you and answer your questions at any time, it's probably their 100th, or maybe their 1,000th, or 10,000 patent examination. So there's an awful lot of talent at the United States Patent and Trademark Office, which you as an inventor can take advantage of. And I think it's really important for you to not just leave all these things to the hand to other professionals, like lawyers who charge $500 an hour. Familiarize yourself with the application process. And when you have a question, no matter what it is, call the United States Patent and Trademark Office, speak to an examiner. Chances are they've not only heard your question once, twice, but 100 times before. And it's better to act on information that you get directly from the horse's mouth. So there's a lot of talent there to take advantage of. They've even, they'll even sit down with an inventor and take them through the process. Each step, tell them what's required in their application. Tell them what is required in each section. So believe it or not, you can pick up the phone and dial their 800 number and talk for an hour if you want with a patent examiner. A lot of talent and a lot of expertise there, which is a wonderful resource for inventors. And it doesn't cost you anything to do it. Differences, continuing with the differences between a provisional and non-provisional patent application. A non-provisional patent application should not only provide a technical description of the invention, but should do so in the context of relevant prior art. When you're describing your invention, unfortunately my mind is stuck on those run fins, but so for some reason I can't. It's like a song you have in your head, you just can't get it out of your head. Once I saw those things and passed them out to the class yesterday, I can't imagine any other inventions right now. But let's take that for an example since it's stuck in my head. One of the things you're going to have to do is you're going to have to research prior art when describing your invention in your patent application. And to the extent that there are other similar devices out there, you're going to need to address that in your patent application so that you can demonstrate that this is an advancement on prior art. Because if you don't demonstrate that in your description, your application is likely to be rejected. So it pays to go in and research prior art to make sure that your application represents an advancement in that art and sufficient uniqueness that your application will be approved. And you'll never know what other simultaneous inventions are out there that are similar to the idea you had until you do a little looking around with respect to prior art. It does happen that great minds, separated by thousands of miles or international borders, do come up with similar inventions, and that'll save you a lot of trouble to familiarize yourself with the prior art. One of the things there's absolutely no substitute for is knowing what you're doing when you're filing one of these applications. And it's not hard to teach yourself. A non-provisional patent application therefore requires the development and an application of a strategy of overcoming a patent examiner at the USPTO. You know, personalities play, unfortunately, a significant role in every patent application. Some patent examiners are brilliant in the way that they will shepherd a patent application along. Others feel as though it's their job to erect as many barriers as possible. And unfortunately, that human element is not something that you can ever get out of the patent application process. So your experience with one patent and another person's experience with another patent may be completely different because of the examiners that you draw. And that's the way it's done. It's a lottery, essentially. Some examiners have an expertise in one area, others in other areas. Some, as I say, it seems like they feel as though their job is to make things as difficult as possible for you. Others almost act like patent attorneys and are very, very helpful in the way that they shepherd an application along, offer advice and suggestions, give you the benefit of their experience and their knowledge about other inventions. So sometimes, you know, it really depends on who you draw, but this is why I say there's no substitute for thorough knowledge and understanding of the process and your invention, including the existing prior art when you're going in there. Assume that everything that you do is going to be scrutinized and questioned. And you need to be able to demonstrate each step along the way why your patent application is deserving of approval. So that's basically what I have to say on patent applications, provisional and non-provisional applications. Any questions at all on this process? Or you feel you kind of have a handle on it? If there's one thing I would suggest to you is that when you're thinking of protecting an investment, an invention, use the provisional patent application vehicle as a way of, as the method of disclosure that you select to protect your invention. It's a great device. It fixes in time your invention. That year grace period is a great thing under the AIA. So make use of the provisional patent application. And when you do make use of it, front load, as Professor Eager would say, as much as you can into the provisional application process. Don't make that application a minimum meet the minimum requirements. Think in terms of a non-provisional application and put as much detail and sophistication into that provisional application as you can. It'll save you money in the long run. It'll force you to learn what you're talking about, and later on it'll make that non-provisional application a lot easier for you. That's my advice when it comes to these things. But now you know the minimum, and now you know what I suggest that you do. It's up to you to decide. All right. The last thing I want to talk about in patents, next week what we're going to do is we're going to get into copyright. So we're going to leave the area of patent law after today's class. I thought it was appropriate that I give you a little law in a law and technology course. I don't want you to go away feeling as though you were cheated, you didn't get any real law. So I'm going to sort of treat this like a law school classroom for the next 30 minutes and talk a little law, because there are some significant decisions that you as inventors need to be aware of, at least generally speaking, when it comes to patent law. And I've saved you a great deal of trouble. I've gone out and I've selected what I think are the most important and most illustrative examples of Supreme Court decisions in the area of patent law, the cases which I think have established the most important principles or developments in the law since the Supreme Court got into the act. I think, as I told you, for more than a century, the Supreme Court was pretty quiet when it came to patent law, and they sort of left that to the courts that were developed specifically for patent law, and more importantly, to the United States Patent and Trademark Office. As I said, there's a tremendous amount of expertise there, and for the longest time, many decades, the Supreme Court seemed to be content to allow the expertise of the USPTO to deal with patent law. But something got into them about 10 years ago. Part of it, I think, can be explained by the rapid advancement in science and technology sort of overcoming legislation. You know, legislation moves at a glacial pace, and society, the society it purports to regulate, doesn't wait around. It moves at a significantly faster pace than the legislation does. And that's partially because of our dysfunctional political system. It's partially because that's the way it's designed. But with technology outstripping the pace of legislative innovation, even taking into consideration the AIA, the Supreme Court has jumped in. And in fact, even as we'll see in some of the cases, it was in some ways dealing with a vacuum that later was filled by the AIA. In fact, one way to appreciate the AIA and the way the whole system, the architecture of the system fits together, is to see that the Supreme Court actually had to become more active in areas of patent law until the AIA came along. So the Supreme Court tends to fill a void, and if patent and intellectual property advancements outstrip the existing legislative architecture, a void is created, ambiguities arise, and the Supreme Court feels it has to jump in. I think it also jumps in for political reasons, but giving them the benefit of the doubt, I think what we'll say here is that from time to time over the last 10 years, the Supreme Court has found it necessary to fill those voids that have developed as a result of the rapid advancement of the world of intellectual property. As I said, since 1982 until 2000, the Supreme Court rarely talked or spoke on intellectual property, and that all changed about a decade ago. During this time, the Supreme Court has really taken the reins. They've shown very little deference to the United States federal circuits. We here in the Northeast have the First Circuit Court of Appeals, and there's also the United States government and the United States Patent Office. In a case called Bilski, which involved a test involving non-obviousness, the Supreme Court just jumped in and changed all the law suddenly in the Bilski case. It showed no deference to the United States government in the Prometheus case, where it rejected the government's argument that any steps beyond the law of nature should render a claim patent eligible. Up until that time, the government's position was the way patent law was looked at. Supreme Court jumped in, perhaps sensing the increasing void in that area of the law, and changed the law. And then it showed no deference to the United States Patent Office after 100 years of showing deference in the Myriad case. when it came to the issuing of gene patents. All of these are precedent-setting cases, and I'm going to go through them now. As a matter of fact, what I did is, at 4 o'clock in the morning today, I was in my office making copies, thinking of you, of all of these cases, because I didn't want you to come away from this class without having, like I said, any law in the law and technology component of it. But as I said, these cases really represent what I think are the most significant developments heralded by the United States Supreme Court in the last 10 years. And I think many of them you've probably read about or heard about or, had some sort of anecdotal experience with, because these are all, in many ways, landmark cases that have changed the direction, in some ways, very fundamentally, of patent law. And let's go through them. Like I say, I passed them out to you so that you can, when you have lots of time on your hands, as I know you often do, and you want to read some law from the Supreme Court, it's there. What I would recommend is if there's one of these that we go through that interests you, especially your area of study or research, I'd suggest that you do read the cases, because they are a primer on that aspect of patent law. First one I want to talk about is the Diamond case. Diamond versus Chuck Robardi. And that's a 1980 case by the United States Supreme Court, and it's one of the first of these really important cases. And it involved this genetic engineer, Ananda Mohan Chakrabarty, who worked for General Electric and developed a bacterium derived from Pseudomonas genus, and now known as Pseudomonas petita. Maybe somebody here can pronounce that better than I can. But it's capable of breaking down crude oil that gets spilled. You know how they sprinkle this stuff on crude oil spills, and the bacterium eats the crude oil, and it's good for the environment. Well, we have a genetic engineer at General Electric to thank for the development of this particular bacterium. So General Electric filed a patent application for the bacterium in the United States, listing Chuck Robardi as its inventor, but the application was rejected by one of those patent examiners, because under patent law at that time it was generally understood that living things were not patentable subject matter under the United States law as it existed at that time. This is an example of one of the things I was talking about, where the development of science has created a void in patent law because it's outstripped the architectural framework that Congress has provided us in at that time, the 1952 Act as amended. You know, when they wrote that law in 1952, nobody could foresee this particular technological development. And there was no means of dealing with it. There was a very real vacuum at the time. The Board of Patent Appeals and Interferences agreed with the original decision, and the Board of Patent Appeals and Interferences is where you go when your application for a patent is rejected. It's the first step. However, the United States Court of Customs and Patent Appeals overturned the case in favor of General Electric. So the United States Court of Customs and Patent Appeals is the next step. So when you lose in front of a patent examiner, you go to the Board of Patent Appeals. It's also referred to as the TTAB. And then when you lose there, you go to federal court. And then when you go there, you end up in the Supreme Court. So when the federal court overturned the TTAB, the U.S. Patent and Trademark Office, appellate division, when they were overturned, General Electric took them to federal court, and the federal court said that the General Electric deserved the patent. That this was this new creature that had been developed, this bacterium, was patentable. And then, in his great wisdom, Sidney Diamond, the Commissioner of Patents and Trademark, appealed to the Supreme Court. And the reason for that was because this really represented a whole departure from the law of patents as old Sidney A. Diamond at that time knew. And so what he, as the patent commissioner, was merely doing in this case is getting clarification for his office. How is he going to deal with these inventions in the future? Well, the way to figure out what to do is to go to the highest court in the land and ask them for instruction. And that's essentially the function of the appeal in this case. And in a 5-4 ruling, the Supreme Court held that, and these words have been cited and recited in thousands of cases since then, not to mention TV, radio, and magazines. A live human-made microorganism is patentable. Subject matter under 35 U.S.C. Section 101. Respondents, microorganism, respondent is simply General Electric, constitutes a manufacture or composition of matter within that statute. A very, very important decision, and one, especially if you have a biology background, I think you really need to be familiar with. But what it did is fundamentally change what was patentable under United States law. Next case I wanted to talk about was State Street Bank versus Signature Financial. One of the things you're going to, I hope, notice in going through some of these cases with you is that some of the things that we've been talking about up until now will resonate with you. You'll say, okay, I know what they were talking about in that case. State Street Bank and Trust, right down here in Boston, involved a decision of the U.S. Supreme Court that was an appeal from the United States Court of Appeals for the Federal Circuit concerning the patentability of business methods. Remember what we were talking about? Whether you could patent a business method or a business idea. State Street for a time established the principle that a claimed invention was eligible for protection by a patent in the United States if it involved some practical application. And in the words of the State Street opinion, it produces a useful, concrete, and tangible result. Very inventive lawyers for State Street Bank and Trust Company came up with this variation of the test for what was patentable. And it had to do with, I believe it was risk management methods that State Street had essentially invented. Back at that time, State Street was full of quants from MIT in their risk management division who designed algorithms and business methods in order to analyze State Street's portfolio risk. And they do that not only for the benefit of State Street, but for the benefit of federal regulators, the benefit of their customers, for the benefit of making a profit. They need to analyze their risk. But mostly, of course, nowadays, since 2008, it's all been about complying with the Fed's regulations concerning portfolio management in institutions like State Street. But they came up with a process, a method, and I believe it was involving risk management, that in their words, produced a useful, concrete, and tangible result, and therefore is patentable. With the 2008 decision in Biliski, however, the useful, concrete, tangible test was jettisoned. So up until Biliski, which we'll get into, this test was the test that the courts used to determine whether or not something was patentable, and they were at that time saying that business methods were patentable if it met this test. But later on, Biliski would come along, and according to that opinion, the useful, concrete, and tangible result inquiry is inadequate, according to the Supreme Court. and the portions of the State Street decision relying on this inquiry are no longer of any effect on the U.S. patent law. So again, this is a case in Lispy, and I show you State Street to show you the direction that the law was going at one point, using it produces a useful, concrete, and tangible result test to determine if something was patentable, to where the Supreme Court came along and said, we're not going in that direction anymore. We're going to take a left-hand turn. The useful, concrete, and tangible result inquiry is no longer adequate. Now the Supreme Court, and we'll get into the Lispy, has basically returned to the old test. Before we get to that, though, I want to talk about eBay, because this is an interesting case. eBay versus Merck Exchange involved a dispute between eBay and Merck Exchange, which held that certain patents on online auction technology that was used by eBay. As a matter of fact, I think if I remember the decision correctly, about 60% of eBay's business depended on their licensing this patented technology from Merck Exchange. And in 2000, eBay initiated negotiations to purchase Merck Exchange online auction patent technology. So they were borrowing it from them, or licensing it from them, paying them to use it, and then they decided, well, you know what, we'd like to buy it. So they started to negotiate with Merck Exchange to purchase the technology. Then, 2 years later, eBay just decided, well, we're not going to buy it. They abandoned their effort, and eBay sued Merck Exchange. Merck Exchange sued eBay for patent infringement and prevailed in a 2003 Virginia jury trial, where the jury found that eBay had willfully infringed the company's patents. And if you read the decision, it's really interesting. I mean, it's just so blatant what eBay did. Basically, I'm imagining this, but if you read the decision, it seems like somebody in a boardroom in eBay sat down and said, ladies and gentlemen, why should we pay for this when we can steal it? And that's basically what they did with this technology. So Merck sued them and won. And then what Merck did is they, the next step was the United States Court of Appeals. After Merck won, they went to the United States Court of Appeals for the Federal Circuit, and that court reversed the district court, stating that there was a general rule that courts will issue permanent injunctions against patent infringement absent exceptional circumstances. I skipped a step. After Merck won, so now they have a judgment against eBay. A jury decided that eBay willfully infringed on their patent. So what Merck did is they were following the advice of their lawyer, any lawyer. Advice I would have given them is to apply to the federal district judge for an injunction, directing eBay to cease and desist using that technology. Of course, Merck wants eBay to pay for the privilege, and getting an injunction from the federal court would cause eBay to reconsider their position. They're not going to violate a federal court order. Just so you understand, an injunction is an order to do something. So you go to the court, you say, hey judge, I won my case against eBay. The jury has decided they're infringing on my patent. I want you to issue an order telling them to stop. And almost any federal district judge is going to do that. So because you've already prevailed on the merits of the case. The district court denied the request. So the U.S. Court of Appeals stepped in, which is what I would have done. I would have gone straight up to the U.S. Court of Appeals and I would have said, what the heck is going on here? You've got a finding from a jury saying they're stealing my client's intellectual property. I went to the trial judge and I asked the trial judge to tell him to stop, and you won't tell him to stop. You're a higher court. Tell the trial judge to tell that client to stop, tell eBay to stop stealing my client's intellectual property. Like I said, eBay depended upon this online auction technology for about 60% of its business. No online auction technology, no eBay. So the U.S. Court of Appeals said, you're right. I'm going to issue this. We're going to tell the district judge to issue the injunction. And that's because, as a general rule, the court will issue permanent injunctions against patent infringement absent exceptional circumstances. Why? Because they want to maintain the orderliness of the commercial system that we all depend on. You don't want to allow eBay to continue to steal Merck Exchange's technology, because if you allow that to go on, nobody will pay for technology. They'll just steal it. So the Supreme Court stepped in, and they determined unanimously that an injunction should not be automatically issued based upon a finding of patent infringement, but also that an injunction should not be denied simply on the basis that the plaintiff does not practice the patented invention. Instead, a federal court must still weigh what the court described as the four-factor test traditionally used to determine if an injunction should be issued. You can stop reading that sentence after the word should not be automatically issued based upon a finding of patent infringement. The rest of that just doesn't mean anything, because it's not something that was put into practice. It has nothing to do with the Supreme Court's decision in this case. What's important about this case is that the Supreme Court was telling the federal court that they were wrong. They shouldn't issue the injunction. And they said, eBay needs to be free to continue to conduct business. The effect of this decision has been really significant for guys like me and for people like you. Because every time I go into federal court and I have a case where someone's stealing technology, I have to overcome this darn case in applying for injunctive relief. It's now almost impossible to walk into the United States District Court and get an injunction against intellectual property infringement. There are very few judges, almost none, certainly in this district, who will give it to you. And part of the reason is this eBay case. I don't know what got into the Supreme Court. I think it's a hideous decision. I invite you to read it and try to follow their logic in it. But I think that this was probably one of the worst decisions they've ever come away with, because the cascade effect has been that a lot of inventors with legitimate claims are not able to get injunctions in federal court because they basically have to totally prove and win their case before they can get an injunction. And that really is destructive of intellectual property, because it gives all the power to the people with the money. And the people that don't have the money, who have to take on these big corporations, can't make them stop because the federal courts won't help to make them stop. And it all goes back to this darn eBay case. KSR International versus Teleflex. This is another great case. One of the seminal cases. This case involves a decision by the Supreme Court concerning the issue of obviousness as applied to patent claims. Now, we've talked about obviousness. Teleflex sued KSR, claiming that one of KSR's products infringed on Teleflex's patent on connecting an adjustable vehicle throttle pedal to an electrical throttle control unit. It's the linkage between the throttle and the throttle control. KSR argued that the combination of the two elements was obvious and the claim was therefore not patentable. Remember, we talked about obviousness and how you have to demonstrate to the patent examiner that you've complied with the non-obviousness requirement. The district court ruled in favor of KSR, but the Court of Appeals for the Federal Circuit reversed the Court of Appeals decision. And on April 30th, the Supreme Court unanimously reversed the judgment of the Court of Appeals, holding that the disputed claim of the patent was obvious under the requirements of 35 U.S.C. 103, and that in rejecting the district court's ruling, the Court of Appeals analyzed the issue in a narrow, rigid manner inconsistent with 103 and our precedents, referring to the Federal Circuit's application of what they called at that time the teaching, suggestion, motivation test. By the way, just so that you know, 35 U.S.C. Section 101, that's the United States Code. So if you, that statute that I talked about that was passed in 1952 is part of the United States Code. And patent law is under Title 35 of the United States Code. And the great thing about patent and trademark and copyright law is it's statutory. It's not soft, subject to a lot of interpretation. It's all written down in the code. So you can actually go to a book called Title 35, United States Code, look up Section 103, and you'll find the test for obviousness. And all the sections involving patent law are right there. Anyhow, so I wanted to talk about this teaching, inventiveness, motivation, and obviousness test, because it bears on what you're going to need to do when you prove non-obviousness of your invention to the U.S. Patent and Trademark Office. The inventive step and non-obviousness test reflect the same general patentability requirement present in most patent laws, according to which an invention should be sufficiently inventive, i.e. non-obvious, in order to be patentable. If it's obvious, it can't be patent. That combination of the linkage and the throttle control in the KSR invention, they claimed was obvious and didn't satisfy the requirements of novelty and non-obviousness. So in other words, the non-obviousness principle asks whether the invention is an adequate distance beyond or above state-of-the-art. Remember we talked about looking at state-of-the-art for your patent application. Make sure that your invention puts some distance between other state-of-the-art. The expression inventive step is predominantly used in Europe, while the expression non-obviousness is predominantly used in the United States. They essentially mean the same thing. They're descriptive terms that describe your putting some distance between your invention and the prior art. No distance, so it's not patentable. The expression inventiveness is sometimes used as well, although the basic principle is roughly the same. The assessment of the inventive step and non-obviousness varies from one country to another. For instance, the practice of European Patent Office differs from the practice of the United Kingdom, which differs from the USPTO. They all have slightly different tests. While they all require non-obviousness or inventiveness, as some other places call it, they all have different tests. And so you have to be aware that what satisfies the USPTO may not satisfy the European Patent Office or the Patent Office in the United Kingdom. And I thought maybe I would take from this KSR case the obviousness test and just give it to you so that you know exactly what you're dealing with. This is the state of law as far as patent law is concerned at the present time with respect to obviousness. And this quote comes right out of the KSR case. In determining whether the subject matter of a patent claim is obvious, either the particular motivation or the avowed purpose of the patentee controls. What matters is the objective reach of the claim. If the claim extends to what is obvious, it is invalid under Section 103. One of the ways in which a patent's subject matter can be proved obvious is by noting that there existed at the time of the invention a known problem for which there was an obvious solution encompassed by the patent's claims. That's what the Supreme Court has given us to deal with when it comes to the obviousness test. Like some things, it's easier to describe what it isn't rather than what it is. But the way I describe it is a clear distance between the state of the art and what your invention does. Next to last case, I think, MedImmune. This is a huge case versus Gentech. MedImmune was a decision by the U.S. Supreme Court involving the debate over whether the U.S. should change to a first-to-file patent system. We've all talked about first-to-file, right? Well, there was a time before, you see this case came down in 2007, when the United States was kind of out there on a limb as being the only developed country in the world that wasn't following the first inventor to file rule. In argument arose from a lawsuit filed by MedImmune, which challenged a patent issued to Gentech. One of the central issues was whether a licensee retained the right to challenge a licensed patent, or whether this right was forfeited upon signing of the license agreement. Think about that, because that can really affect how long a patent, the effective control a licensee has over a particular patent technology. The origin of the dispute was a lengthy interference proceeding between Gentech and Celtech, which led to the issuance of a new patent in 2001, 18 years from the original filing. This effectively granted Gentech a patent term of 29 years. I think Professor Eager was talking about these General Electric, this welding process that they had. This is how a lengthy interference proceeding and litigating a patent can actually affect, if you're successful, can affect the term of the patent. MedImmune was a licensee of the patent, but argued that that the term had been improperly extended and that it need not continue to pay royalties past the original expiration date in 2006. The case was decided in favor of MedImmune, and the U.S. Patent and Trademark Office declared the patent invalid. They said, hey, 20 years, that's it. I don't care how long your interference proceeding took. Gentech appealed the case to the USPTO, appealed the USPTA ruling, and the patent remained valid and enforceable until the appeal was concluded. The court held that the licensee adequately raised and preserved its contract claim and was not required to terminate or breach its license agreement prior to seeking declaratory judgment on patent invalidity. In other words, the court, well, here's the impact. MedImmune and subsequent cases like it reshaped the face of licensing. It destroyed the objective standard for bringing a declaratory judgment action and made the standard for bringing an action much more lax than it ever was previously. This line of cases has effectively redistributed the power in license negotiation and existing license agreements. As things currently stand, any licensor or patent owner with any doubts about the validity of their patent or a strong urge to avoid litigation must walk on eggshells around licensees for fear that they could be involved in litigation, infringement litigation at a moment's notice. In addition, MedImmune cases and cases like it have potentially permanently dropped the value of all patents due to the increased inability of a patent owner to enforce their rights and risks associated with that enforcement. So you see what's happened here. MedImmune got in a dispute over interference that lasted almost a decade. And what the court ultimately determined is that the licensee didn't have to pay for those rights, that the patent was not extended. And so, of course, you get into a big dispute with someone, you get involved in litigation, and you license your patent to somebody. They're not going to want to pay you past the 20-year period, no matter how long your interference proceeding goes on. And we find this is not that uncommon, especially in the biotech field, where human trials are involved, that you were talking about earlier. How are you going to license something? The fact is that that clock starts ticking, and it's 20 years, no matter what the FDA does, no matter what sort of interference proceedings you get involved in. And so, when you're licensing this technology, you've got to take that into consideration. A lot of people don't want to license this technology because they're afraid that they're going to lose the right to have the exclusive right to the property. So this case really reshaped licensing, and it really did drop the value. Think of it. If you're a company and you're licensing a piece of technology and you get involved in an interference proceeding, and you think that your patent protection lasts the length of the interference proceeding, in this case 29 years, that patent's going to be very valuable. But what this case established is that the cutoff date is the cutoff date, no matter what's going on outside of the U.S. Patent and Trademark Office. And that, of course, reduces the value of something. You can't license it beyond the 20-year patent period because even though you're involved in an interference proceeding or in trials, the clock keeps ticking. These are just some of the impacts that have been noticed since the Supreme Court decided MedImmune. More serious side effects may still come. They keep sticking their nose into this business. The last case I think I have for you is the case I've already mentioned, the Bilski case. It was a case decided by the Supreme Court holding that the machine or transformation test is not the sole test for determining the patent eligibility of a process. But rather, the test should be whether or not it's a useful and important clue, an investigative tool for determining whether some claimed inventions are processes under Section 101. So doing, the Supreme Court affirmed the rejection of an application for a patent on a method of hedging losses in one segment of the energy industry and making investments in other segments of that industry on the basis that the abstract investment strategy set forth in the application was simply not patentable subject matter. I think we talked about this before. Remember, in the very beginning, we talked about how it has to be a tangible form, how processes and methods aren't necessarily patentable. And this, is the answer to the State Street case, where their risk management model was, up until Bilski, something that was considered patentable. This came along and changed all of that. Another really seminal and important Supreme Court decision. The last case I have for you, this is definitely the last case. This is, next to last case. I've gone over. So Prometheus is the other case, and the next case after that is Myriad. We've mentioned them both very quickly. I suggest that you look at them because Myriad was the one that held that genes were patentable. That was one of the things that was talked about early on in our case. And Mayo was a case that involved the field of personalized medicine. And I leave it to you to look at the handouts I've given you. I'm sorry I've gone over it for 2 minutes. I hate it, but when it comes to law, I can talk forever. Anyhow, that concludes patents. If you have any questions, you let me know. Next week we're going to start on copyright. I'm going to have somebody come in. I'm going to have a real live copyright lawyer come in on Friday and talk about that. We'll cover copyrights next week, trademarks the week after that. And assuming all goes according to the evaluations, we're going to do one day on employment agreements after that. So you'll walk out of here knowing everything you need to know about intellectual property and that contract that they're going to stick under your nose when you go and get a big job with one of these big firms. So thanks. I'll see you next week. We got